Tonight, the Etan Patz trial ended in a mistrial after 17 days of jury deliberations. 11 jurors couldn't convince the one holdout to convict Pedro Hernandez. Well, our panel of attorneys, they'll weigh in on how they deal with juries and how unpredictable juries can be. Then, in the wake of all the violence in Ferguson and Baltimore, prosecutors aren't just prosecuting, now they're also peacekeeping. We'll discuss how times have changed in these tough times. Also, the Patriots, they're fed up, and now, reportedly, they're lawyering up. The team is considering suing the NFL over the Deflategate penalties. I'll ask our legal team whether they got a case or if this is a Hail Mary. Good evening and welcome to RFL. I'm Richard French. Thanks so much for joining us tonight. Now, tonight, as is almost every Wednesday night, it is about the law. Now, first on the docket, the Etan Patz case. Pedro Hernandez, he was on trial for the 1979 murder of 6-year-old Etan Patz. Patz, as many of you may remember here, he disappeared when he was walking alone to his school bus in Soho. It was the first time he was allowed to do that in the case. It rattled parents everywhere. And it also changed the way, in many cases, parents watch their kids. Patz was also one of the first missing kids to appear, on a milk carton. Now, to that end, Hernandez confessed to the murder and the kidnapping, but his defense attorney said it was a false confession and that he's mentally ill and there was no physical evidence to connect him to that murder. 11 jurors wanted to convict him, but one did not. And after 17 days of deliberations, the judge declared a mistrial. The one holdout says it wasn't easy being the odd man out.
It wasn't fun. We had huge respect for each other, and it did get heated sometimes. It wasn't easy, but it wasn't torture either. It was just very, very intellectual. I feel all of my fellow jurors were very respectful of my position.
Now, I wanted to bring our attorneys in and ask about their experiences dealing with situations like this with juries. And let's bring in our legal panel to weigh in. Jim Kousouros, criminal defense attorney in Manhattan. He sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the bar associations in Queens as well as New York City, and is a visiting professor at the University of Birmingham in England. He also was former prosecutor in New York City. Mayo Bartlett, an attorney at the law offices of Mayo Bartlett PLLC and a former chief of the Bias Crimes Unit at the Westchester County DA's office. He also has been involved in a lot of high-profile civil rights cases. And we're also joined by Susan Wolf, criminal defense attorney at Blank and Rome, and always the smartest person at the table. All right, guys. And I'll start with you, Jimmy, and because you, like I said, have been on both sides of this, as of you, Mayo. Picking a jury and then divining if there's one person on that jury here who could go, let's say, break from the herd a little bit. Put your prosecutor hat on first, then your defense attorney hat. Back as a prosecutor, when you thought you had an ironclad case here, what worries did you have once the jury got charged and they went in there? Were you looking and saying, that guy could be trouble for me?
Well, during the trial, you're looking at the jury and, we'll all be able to attest to the fact that we're wrong so many times, because you look and you think that this person could be a problem, this person could be a problem. When you get the opportunity to speak to them after the trial, you're wrong. They weren't your problem. Somebody else was the problem. But in this case, this is the system working at its best. This wasn't a lunatic juror who came out and said, I couldn't convict because the sky was gray. And the way the deliberations went, it was back and forth and back and forth. He had a legitimate reason. There was a confession. Confessions need to be corroborated. He could not find any corroborating evidence. Several of the other jurors for much of the deliberations couldn't either. And he stuck to his guns. And as much as you may not like the verdict and people may not like the verdict, this is what the system is about. He wasn't browbeaten. Nobody on the jury was trying to browbeat him into changing his mind. And he had a legitimate reason for his inability to convict.
It sounds like it's a little atypical, though, Mayo, in terms of usually when you have an 11-1 jury split here, especially for something where they were deliberating for 2.5 weeks. some of the 11 here, you got 12 angry men, or as the expression goes, or men and women, where somebody wants to strangle the guy to say, what are you doing? How could one guy not see what the rest of us are seeing?
Oh, absolutely. And what happens is sometimes judges actually make promises to the jurors, and they tell them, look, we're only going to be here. This is a 3-week-long trial. And I always am concerned about that, because my fear is you only get 3 weeks of justice, and when you start going into that 4th week, people have vacation plans, they've got career obligations, their kids are doing things, and they want to just get finished with the case. And in those cases, it generally benefits the prosecution, because it's also difficult to find that nobody's responsible for a homicide. And we know that quite often people who are not actually responsible can be convicted. So it's a lot easier for the prosecution, even right now. The case is not over. No. They can retry this case. So for the defense, it's a hollow victory, because you're coming right back to deal with this same thing. And now you understand that you only had that one juror. The other issue is that lots of times the other jurors do change their positions. As Jimmy was saying, you may have a 6-6 split, and as time goes on, it's easier to sway people toward prosecution and toward a guilty verdict than it is to convince them that a person's not guilty.
I got to imagine, Susan, though, when you're looking for a verdict and you just have one person that's sitting on the fence. To Mayo's point here, defense attorneys got to be sweating bullets here, because they want to bring that verdict in for Friday so they can have their weekend. They haven't seen their family, or they haven't done whatever for so long. But on the flip side, when there seems to be such a preponderance, I'm not saying necessarily this case, but of evidence here, you got all but wonder what goes on in that jury room, where they're trying to get that person, as they would argue, to see the light of day.
We all wonder that, and we wish we could be a fly on a wall. But in the category of cases that don't reach a verdict, mistrials, hung juries, 11-1 seems to be, in my experience, almost exclusively the hung juries I've seen have been 11-1. I've never seen a 6-6 or an 8-4. So for mistrials and hung juries, it often comes down to 11-1.
Is there recourse if that one person, and I'm not saying in this particular case, because you seem to be a very reasoned juror, seem like the rest of the jurors at least rationalized, if not agreed, and they understood that he took his job seriously. But if you just have a person who's unhinged in there and bringing their personal baggage into the jury room here, that you're just like, you're not even responding, fellow jurors, you're not even talking about the case at hand here. You're bringing what happened to you 20 years ago. What's the recourse, whether you're a defense attorney or even a prosecutor, where you say, time out here, this wasn't a level playing field. We didn't, when we were trying, to, what do you call it, when you have how many, where you can exempt your challenges or peremptory challenges. They didn't pick it out at that time, but it clearly was visible in the jury room that this person had an agenda. What's the recourse then?
The recourse during the process is for the jurors to send out a note and say, this person won't deliberate. This person, won't engage in what we're supposed to do and is not doing it. And then the judge gives an instruction. And 11-1 splits often involve the kooky person, the loony person who has some way out reason.
But what if it only materializes once the jury's charged and they go there?
Here's the rule is that you cannot challenge the verdict based on whatever went on inside the jury room. So no matter how poorly anyone behaved, that's not a basis to challenge the verdict. You can challenge the verdict when some outside influence is brought to bear on the jury or the jurors.
But occasionally that outside influence can be, let's say if you have a juror who is an attorney and that person substitutes his or her expertise for that of the judge and starts to instruct his or her fellow jurors as to the law, then it's juror misconduct that can't be cured.
Cause trouble, isn't it?
It is, but you're never getting anywhere unless the jury reports it and the judge deals with it.
So real short,
that's why we have alternates.
What is, if there's one common thing after you interview the juries after a decision that drives you the most batty, is it that they misinterpreted, the threshold for guilt or innocence? Is it that they went off in a completely different tangent? What is it that drives you most nuts after the fact when you find out why people, in effect, decided the way they did?
There is no one thing. The stories that I have heard about what jurors were bringing in there is off the wall. Let me tell you something. You can put a client on sometimes, and if he's a good kid, you know, I've had jurors come up to my clients and say, "Don't do it again."
And your client was in Minnesota and he's charged for committing a crime in Brooklyn, right?
So there's the list is endless because you don't know. You just don't know. But, you know, and this is a completely different topic, but jury selection is that important because I am telling you, we get to weed out so many jurors during the selection process, whereas in federal court, we do nothing.
Yeah, real quickly, you guys got horror stories too after the fact?
Well, there was one case where the one woman hung the jury because she said they all thought he was guilty and they didn't want to talk about it. And I wasn't going to vote for guilty under those circumstances. So it's the jurors who say he was so guilty, who didn't really even try.
Bother engaged.
That's what bothered me.
I had one where it was crystal clear that it was impossible for the witness to see what they say they saw. Kareem Abdul-Jabbar wouldn't have been tall enough to look over the fence. And one of the jurors thought I was clever because I was able to show that, you know, the angle and the distance was just physically impossible. But the biggest thing, the biggest frustration for me is when the jurors don't understand the judge's instructions. And we're putting them in a position that's unfair because they're not lawyers and they're given a complex set of instructions. A jury charge can be this thick.
And it's not even in English.
It's not in English. The jury doesn't understand it. They hear it one time and then they're told go back and deliberate. They don't ask for any readbacks, and half the time the attorneys can't even agree on what the charge should be. So the judge ultimately makes that decision. It would be as if you took 12 people and told them to determine what type of surgery should occur.
Really?
Oh yeah, absolutely.
And that's at the end, right before they go into the room. Okay, we're going to jump to a quick break. When we come back, obviously we've all seen the riots in Ferguson and Baltimore and game changers in the way that cities deal with high-profile cases. We're going to explain why things are getting very complicated very quickly for prosecutors and how some are choosing to handle these fluid situations.